This is LAWS 13013, Legal Professional Conduct, Week 6, Duties of Representation, looking at tutorial problems 26 to 27. Now, this week we had a problem with the actual recording of the live class, so I'm just making this catch-up video for you. In relation to the first assessment, this is the breakdown of grades. The average was 14.6. If you're at the lower end of this graph, don't be too concerned because it's only a relatively low percentage of assessment and there's much more to come. So it's not the end of the world, but you can just see the spread of grades. All right, so this week we've got two problems looking at the duties of representation. The first problem involves whether a lawyer can make a personal conscious choice not to represent someone or even a whole section of society. And it's given there the example of a fundamental Christian who refuses to associate with Muslims, but it could be any sort of other example. So that's just by way of illustration. So the way you approach this particular problem is to look at, firstly, the distinction between barristers and solicitors, because there's a big distinction. In relation to barristers in particular, they are subject to the cab rank rule. Solicitors have much more leeway in terms of who they represent. Aside from that, you also need to have a look at the anti-discrimination legislation, which applies to both sets or both sides of the profession. If we have a look at the barrister's side, the cab rank rule itself is found in Rule 21, and you can see there a barrister must accept a brief from a solicitor to appear before a court in a field in which the barrister practices or professes to practice. So there's the first exception. It has to be in a field the barrister practices or professes to practice. So if it doesn't fall within that, that's an out or a way out of the cab rank rule. But then the rule goes on to say if the brief is within the barrister's capacity, skill and experience. So there's another route if it's not within their capacity, skill and experience. B, the barrister would be available for work as a barrister when the brief would require the barrister to appear. So in other words, are they already committed to some other professional or personal engagements which have the real possibility to prevent the barrister from being able to advance the interests of the client? It may well be that they're booked for another trial, and there's uncertainty with trials because a lot of them settle on the door of the court. So if they're booked for another trial, obviously they can't be in two places at once. The third requirement is that the fee offered on the brief is acceptable to the barrister. Now, obviously, if the fee is too low in terms of their normal range of fees, then they're quite able to reject the brief. But if it's within their normal range of fees, then they do fall within the requirement of the cab rank rule. Then there's a whole lot of exceptions in rules 95, 97, 98 and 99, which we'll look at in a second. But just look at rule 22 there, just in terms of the acceptable fee. It's not permissible for a barrister to set fees so high that it will deter the solicitor. Just looking at rule 95, this deals with when a barrister must refuse or must return a brief. If you look at the requirements of that rule, a repugnant client is not one of those circumstances. So fundamental Christian beliefs are not an exception to the cab rank rule. 97, rule 97 relates to refusal of brief in circumstances where there's confidential information which creates a conflict of interest. Obviously, you can't have a barrister who is in a situation of conflict of interest due to some information they have concerning the particular potential client. 98, that's talking about where they're committed to appear or likely to appear on another brief. 99, it's a situation where the brief is not offered by a solicitor. Now, it is possible for a barrister to accept a brief from somebody who's not a solicitor, Rule 24B, but it's highly unlikely. Barristers like to receive properly formed briefs to counsel. and it makes their job a lot easier. In terms of what a brief to counsel looks like, in a civil case, essentially it is usually a printed document in the form of a folder, and it'll have different sections within the folder. The sorts of sections you'll see would be a section at the beginning which just has the general instructions to the barrister. It might have a summation of what the arguments are, if it's a good solicitor. It will then have copies of the relevant pleadings. It will then have copies of any of the relevant documents which have been discovered that are pertinent to the case. It will then have copies of potentially important cases, or at least a list of important cases with respect to the particular matter, etc. So that's basically it. Increasingly, we're seeing briefs that are in electronic form, particularly if it's a very large case. But smaller cases, generally, they're wrapped up in a folder. They usually have pink ribbon around them. It's a sort of old tradition. Okay, there's also some general rules, in particular Rule 5 in relation to barristers, because it does recognise that legal representation is better secured if there is a bar, generally a bar, whose members accept briefs regardless of their personal beliefs, don't refuse them except on proper professional grounds, and they compete as specialist advocates with each other. Because that's the nature of the adversarial system, that the two barristers on either side argue out the case and bring the points before the judge, and the judge makes a decision on the particular arguments that are received. It's not like the civil system, whereby the judge goes on an inquisitorial process and does investigations. So we have an adversarial system, which relies heavily on the skills of the barristers. Rule 37 also talks about a duty to the client, and that they must promote and fearlessly protect by all proper and lawful means the client's interests to the best of their skill and diligence, without regard to his or her own interest or any consequences to the bar. So the barrister. So the notion is that you could end up having a repugnant client that you're dealing with, and the cab rank rule requires that to happen. Now, it's not like a cab rank at the airport where everybody is in a sequence. So it doesn't go by seniority, for example. It's just where a barrister is briefed by a solicitor, then that's when the issue of the cab rank arises, and they have to make a decision whether they'll accept the brief. So there's no particular order of barristers as such. There is a quote there, which I've included in the answer guide, from Mr. Justice Wilson, and he actually suggests that if you have a repugnant client, that you should actually tell the client, frankly disclose your views to the prospective client and inquire whether your views are such that the client may still wish to retain your services. But nevertheless, if they do, that you will, according to the rules we looked at earlier, act to your best ability and skill and diligence for the client. So that's the bar's position. Solicitors, on the other hand, cab rank rule doesn't apply. That's the first point. And the reason for that is it's perceived there are a greater number of solicitors than barristers, which is true. So if solicitors refuse representation, there'll be plenty of other solicitors who can represent. It's also solicitors are also seen as a filtering of system for unmeritorious claims. And you've got to remember, when you do civil procedure, you'll see that if you bring an unmeritorious claim, you can be personally liable for costs. So, you have to do your job to the best of your ability as a solicitor and not bring unmeritorious claims. Because if that happens, then the whole justice system grinds to a halt and clogged up with claims that should never have been brought. Solicitors, of course, have other fundamental duties. As you can see there, Rule 4, act in the interest of the client, honest and courteous, deliver their services competently, diligently, promptly, as reasonably possible. Don't compromise their integrity or independence, and otherwise comply with the rules. So that's essentially the position of the barristers and the solicitors in terms of the rules that apply to them. But of course, there's legislation that also applies. That's the Anti-Discrimination Act, 1991, Queensland. There's also an equivalent Commonwealth one as well, but we'll focus on the Queensland one. So you can see there in section 46, subsection 1 of that Act, it's talking about a person who supplies service must not discriminate against another person by failing to supply the service or by treating the other person unfavorably in any way in connection with the supply of the service. And of course, if you're denying somebody the service, that would be a form of discrimination or failing to supply. Services under Section 4 includes the services of a profession, which includes the legal profession. Discrimination on the basis of certain attributes is prohibited in Section 7.1. You can see religion is one of them. Or association with or in relation to a person identified on the basis of any of the above attributes. Our problem involves just direct discrimination. And that means in Section 10, on the basis of an attribute, so religion, happens if a person treats or proposes to treat a person with an attribute less favourably than another person without the attribute, or would be treated in circumstances that are not the same or materially different. So if you're denying a Muslim a service or somebody else who fits within these sort of attributes, that, because of their sex or marital status, age, race, etc., then that is a direct form of discrimination. And it doesn't matter what your motive is for discriminating. There are enforcement provisions via Chapter 7 of the Act, and there's conciliation and tribunal hearings. So barristers and solicitors are subject to that as well. So I think that gives you a pretty clear picture of what the bar and the solicitors are required to do when confronted with a client. Problem 27 involves a reasonably complex case, and what you need to do is to read through the extract there from the Queen against White, 1995-77, Australian Criminal Reports 531. So what this involved was counsel for the accused proposed to withdraw during a murder trial estimated to last 10 weeks. The trial had already started, and their primary reason for withdrawal was that they had been dismissed by the client, and it had become impossible for them to communicate with the client being the accused. And therefore, they'd been unable to obtain instructions. And further, the barrister requested and received advice from the Bar Council that he should withdraw. Counsel also submitted to the court that he did not require leave to withdraw. So there's a few issues in this particular case, which makes it interesting because not all cases are easy, and this one's got lots of things going on in it. So the judge, or the acting judge of Bar, noted that the barrister gave two reasons for his wanting to, or his proposal to withdraw. Firstly, he was diametrically opposed to the view that the judge had taken concerning the accused's fitness to be tried. So earlier on, the judge had said this person is fit to be tried. Secondly, that there existed a conflict as to who, in effect, represented the accused and had the power to give instructions in the trial. And that confusion arose because of the mental health of the accused. So there is the Mental Health Criminal Procedure Act required the trial of the accused on the charge of murder should continue under Section 13. However, there was also the Guardianship Act 1987. So if a guardian had been appointed under that act, then the guardian would be able to give instructions instead of the accused. So there was a bit of a conflict between these pieces of legislation. And that on one view, the whole thing could be referred back to the Guardianship Board to have the status of the guardianship order that had been previously made sorted out. All right, so you can see the complexity of the particular case. The judge did ask whether the defence might wish to raise again the question of the accused's unfitness to be tried. but they decided not to. So the problem was not one of having general instructions, because the barrister did have general instructions to defend the accused. But what had happened is that after those instructions had been given, there was this impossibility of communication to the client because the client refused to talk to them. So they could continue, in theory, to run the trial based on the general instructions they received at the time of its commencement. Barrister did inform the judge that he had no ethical problem in appearing on a further unfitness to be tried inquiry, and that if he withdrew, the solicitor could continue to represent the accused, presumably as a solicitor advocate. That's not really advisable in relation to a murder trial. The Crown, who's prosecuting this, indicated that they opposed any adjournment because they wanted the trial to proceed. But neither side in the end raised the question of unfitness to be tried, so that issue really fell out of the picture. There's no specific bar rule concerning where a barrister tells the judge that they're withdrawing, or whether there is a requirement to seek leave. There is the general overarching provision that the Bar Council can inform a director barrister from time to time as to the etiquette of the bar, and that's what the barrister had done, sought advice from the Bar Council. So the rules which govern the conduct of the barrister are no way confined just to the printed and published bar rules. It also extends to the opinions that the Bar Council may have in areas that are not covered, as is the case here. On the other hand, the court might have the responsibility to decide whether the barrister should be allowed to withdraw, because after all, the court is in charge of its own procedures. And one of the procedures is who's in fact representing people in front of the court. So you would think on the face of it that the court would have a discretion as to and should be asked whether a particular barrister sought leave to withdraw. So there's all sorts of conflicts going on in this particular case. The judge then tried to figure out, well, what do we do in this situation? So he then went on a fishing expedition, if we can put it that way. He looked at decisions in the United States, which said it really is dependent on the discretion of the trial judge, hence there should be an application made to withdraw, and the judge should be asked to exercise their discretion. There were some Canadian cases. There was one in British Columbia, which basically allowed the counsel to withdraw, and the trial would continue with the accused being unrepresented. So that wasn't really a good outcome here. And then there's an English decision which they actually did follow in this case in the Court of Appeal, and which said it was not within the province of the judge during the criminal trial to dismiss counsel or a solicitor, or to order them to remain if counsel were required by the etiquette of the bar to do otherwise. So basically that English Court of Appeal case was saying you would look to the etiquette of the bar, and if it suggested that the barrister should actually withdraw, then they would be permitted to do so. But what's interesting about this case, at the end of the day, the judge sat right on the fence and said, it seems to me, although this court may have a general discretion, it may not extend to a case like the present, where the counsel is obliged, because of professional etiquette, to withdraw. So that's one answer. Alternatively, the matter may be that although a discretion exists, it ought not to be exercised against a grant of leave in those circumstances. But he didn't think at the end of the day, he being the judge, thought that the outcome was really any different either way, because he would exercise the discretion, if he had one, to grant the leave, or if there was no discretion, then it would just be appropriate to say that the barrister would just inform the judge that they were withdrawing, and that would be noted. So if you look at the actual questions, how could Mr. Coombs state that he was dismissed by the client when he said over the past few weeks the accused had sacked him? The answer is simply it was impossible to communicate with the accused. He was unable to obtain obstructions, in effect, it was constructive dismissal, and that he had advice from the Bar Council to withdraw. Second question, why would Mr. Coombs have ethical problems concerning an inquiry by the court into the accused's unfitness to be tried? In fact, he didn't have an ethical problem. Because he was quite happy to have a further unfitness to be tried inquiry, although that never happened in the case ultimately. The problem was he couldn't get instructions, lack of communication. He was disengaged professionally, and on that basis, he couldn't really represent the client. And there was also some conflict with the guardianship orders as to who in effect represented the accused and had powers to give instructions. And the last question there, do you think Bar AJ was correct in believing that if there are professional ethical obligations of the barrister obliging him to withdraw, that ruling or custom should prevail over the discretion of the court? So Bar followed the English Court of Appeal, which recognised the discretion, but found it to be constrained by etiquette as dictated by the QC of the Bar Association. Now, in reality, discretions are unfettered. So what that means, it should not be constrained by etiquette. It's just that etiquette would be a factor taken into account in the exercise of the discretion. So the court should ultimately control its own processes. So at the end of the day, the answer didn't matter which way you went, either in terms of the use of the exercise of the discretion or simply being informed of the withdrawal. But the better approach is the exercise of the discretion. All right, well, that is what this week's about. That's the last week for me. So from here on in the course, Dr. Victoria Lambopoulos will be your lecturer. So I just wish you luck with the remainder of the course. If you have any questions on any matter actually in the course, feel free to email me if you're having a problem. But I wish you the best for the rest of your studies. Thanks very much.